It is basically the fall of 1998. I have been placed by our dean then, Judy Areen, on what I view as the equivalent of a law professor's hell, which is a long-range planning committee. She said, I want everyone to give a big, hairy, audacious goal. I remember sort of exactly what I said. I said, we could have a Supreme Court Institute, and the Supreme Court Institute could have a signature program, which would be the moot court advocates before the United States Supreme Court. Georgetown is singularly qualified for it. No other law school could do it. And then about 5 or 6 months later, Judy Areen called me into her office, which was never good news, and she said, Richard, I heard about your Supreme Court Institute idea. I want you to do that. And pretty soon, the word got out.
So the Supreme Court Institute is, I don't think we would have realized it at the beginning. It's really a phenomenal and a unique institution. It started as a way to bring together the expertise of the Supreme Court bar, people who are experienced Supreme Court advocates, and to do moot courts for people who are coming to DC and maybe aren't as experienced. And so in the early days, it was, just a handful of them a year, and it quickly just caught on like wildfire.
First year, with no advertising, not attempting anything like that, we mooted 40% of the docket. We didn't have this nice courtroom. Richard would get a seminar room. So I distinctly remember one moot I did, mooting the advocate was John Roberts in one of the seminar rooms.
I think about a year in or so, I wrote Judy Areen, and I said, Judy, we're building a new building. Why don't we put a room in there which looks like the actual Supreme Court bench? It won't be as big, but it'll be the same wraparound. It'll have the same carpet. It'll have the same clock behind it. The lectern will be the same distance, which is about 72 inches from the court.
The most important thing to advocates to understand is that you are never closer to the court, the panel of judges, than you are in the Supreme Court. You're just about sitting in their lap.
We would go through a rigorous moot court, very tough, for about an hour. Then we'd have about an hour of discussion, and very, very candid discussion. And that was part of what made us, I think, very effective. We weren't cheerleaders.
First-time advocate or not, we're going hard. It's not as though we took it easy on anybody. We are giving every advocate a pretty good sense of what the argument will really be like in front of that court.
The thing that's the most special and different about SCI moot courts is the quality of the panelists, recruiting just really top-notch advocates who have a lot of experience with the court and before the court.
I'm a believer that Georgetown has to be giving the best moots, and one of the reasons is I think the depth of our justice bench. We know some people, for example, are really good with first-time advocates, or we'll have really, really experienced advocates, and we'll know some people are meant, their highest and best use is to be on a panel for somebody who's really experienced or a gifted advocate to really challenge them and push them.
I've probably been mooted 25 times or so by the SCI, and the thing that I'm struck with each time is just the total variety of people mooting me. They come from the left, the right, the center, from Mars and Earth and Venus.
Being nonpartisan and non-ideological in any direction was absolutely central to the idea.
Part of the strength of the Supreme Court Institute is that it's not, someone who's going to get their colleagues to come and moot them, where all those people are kind of in the same legal neighborhood. You're going to get people who are, really looking at the issue in a different way.
I think advocates are eager to sign up because it's the gold standard. They know they're going to get an absolutely valuable, sort of straight shooting, unbiased opportunity to try out their case in front of great judges. The opportunity to have somebody like Irv Gorenstein do a moot court for you, that's worth its weight in gold.
Being able to watch people just do what they do really, really well, I think is inspiring for students. To be able to come into a moot and see how it actually gets made in real time, and strategic judgments lawyers are making. It was invaluable as a teacher.
It was a great experience where we attended the moot with my fellow classmates. And when you attend moots with other people who've cleared conflicts, you're able to actually discuss the case afterwards, which is great. It's very interesting when I think something is a phenomenal answer and one of my classmates thinks that's not a great answer, or when I think the style of advocacy was good, but my classmates think otherwise. The next class after the moot, getting the perspective of the professor, because she was also on the panel, if I'm not mistaken. That was a great experience.
They get to see the sausage being made in real time, and they can see how even an advocate who's argued in front of the court a few times can really gain knowledge from the other people in the room, and then they can see sometimes the members of the panel won't agree with each other. And that, I think, is less helpful for the advocate, frankly, but more helpful for the students.
I really enjoyed seeing a panel shift from an hour of grilling an advocate to then being incredibly collegial and kind and trying to help them strengthen their argument, and the tenor that would change in the room was miraculous to see.
When you can get the best advocates in our day talking to students about what they were thinking about, I don't know how you could get a better education than that.
We truly are 25 years young. We're trying to improve the experience for students so they get the most out of it. We're trying to make it available to more faculty. It's my view that pedagogically that's really important to Georgetown, because then we're doing something that no other law school in the country can do. We're now mooting the whole docket, 95% and up. If we get to the point where everyone believes that there's a way to enrich their course by tapping into this, then we're home.
We've also really been blessed and benefited over the years with some fabulous Georgetown Law students who year in and year out, especially in the early years, they were there and they were fabulous. And a lot of them have gone on to be quite successful lawyers, which is wonderful.
The fact that it was part of my job to attend moots and watch oral argument in cases that were imminently going before the Supreme Court was an unforgettable experience and taught me so much throughout my years here, and was really the best of both worlds in terms of being a work experience, but also beneficial in my academics.
They dedicated so much time and energy toward getting me to transition from being a law professor to a legal advocate. I can't thank them enough. This is an institution that has dramatically made a difference.
My father once told me years ago, if you build something you care about, then build in a way that it doesn't need you. And by the time I left Georgetown, it didn't need me. It's fully integrated into the law school. They max out on the students over and over again. And that's because of the quality of the school, its proximity to the court, where the bar is, the number of faculty who are engaged in advocacy. There's no other school remotely able to have all those ingredients put together. The only shocking thing is it was 25 years ago.